And we want to find out for sure today from a consumer lawyer, can a collection company, can they purchase debt? I mean, obviously they can purchase debt from a company, but are they legally allowed to collect on that money even though they didn't have your signature or they're not the original debt collector? Can they really collect the debt?
They can. Encore Capital Midland files about 500,000 lawsuits a year throughout the country.
Wow.
If you're not paying it, what can they do? Can they
Yeah.
sue you if they're within the statute of limitations? Yeah, they can legally still come after you.
Mm.
Even if it's outside there, they.
Hey, what's going on, guys? Calvin Russell here, CEO and founder of 850 Club Credit. Hope everyone's doing well today. Listen, we have a super special guest today. Okay. Now, listen, we've never had a consumer lawyer in here today. And listen, we're going to be diving deep into collections, bankruptcy, and just what happens in general when you all say, okay, what's my legal position here? Do I have to pay this company? What happens if I don't? Should I consider bankruptcy? We're going to cover as much as we can in a short period of time. So get your notepads out as I want to introduce you to my friend, Mr. John Skiba. John, can you hear us okay?
I can hear you great, Calvin. Appreciate you having me on this morning.
Absolutely. Absolutely. So, John, listen, my audience, they like to get right into it. But of course, right before we do, I want to know, of course, how long have you been doing consumer law and how did you find yourself, getting involved with this in general?
Yeah, I've been practicing law for about it's almost 22 years,
Wow.
and throughout the entire time, it's almost all been consumer debt type issues, consumer bankruptcy, debt collection lawsuits, defending consumers and those kind of matters. And it's a good question of how I got into it because it's not something, as a kid you grow up thinking, oh, I want to be a bankruptcy lawyer when I grow up. Um,
Right.
but when I was in law school, I had a law professor. One of my professors, he was one of the authors of this treatise on bankruptcy, and he actually made
Mm.
it's kind of a dry subject, pretty interesting. And so it's something I always kind of gravitated to. And when I opened my own practice, pretty soon after law school, I jumped right in. And so I started doing bankruptcy. I realized that a lot of people don't need bankruptcy. They were dealing with like creditors who are coming after them, with debt collection lawsuits. So I kind of started
Right.
kind of a little niche area there. And it's just kind of rolled into what it is now, where I've been doing it for 2 decades and helping consumers with debt issues.
Wow. Okay. It's like you said, no one, well, I won't say no one grows up and say, listen, I want to be a consumer lawyer. But you know what you do is so needed because people have these issues. They don't know who to talk to. There's so much bad information right now that's
Yep.
online on YouTube. And I feel like it's just sending people off. It's sending people down the wrong direction. Okay. And that's what I want to dive into today because I know right now it's a lot of stuff that's going on in the economy. Okay. But here's the thing, let's go ahead and go right into it. What should someone never do? What should someone never do if they're being sued by a debt collector? What's your take on that?
The statistics are nationwide that those people who get sued by debt collectors,
Yeah.
95% plus don't respond to the lawsuit.
Mm.
And by not responding, and I get it, you get the lawsuit. I always say people go to the worst place in their mind of, they feel like they're going to go to jail or they're going to lose their home or
Mhm.
something. And so
Mhm.
they don't act. But by filing a response, a written response to the lawsuit, you buy yourself a lot of time. You open up the ability to negotiate, and really you avoid a default judgment. If you don't respond to civil lawsuits, like a collection lawsuit, the court will actually just give them a judgment, everything they're asking for, plus interest, plus attorney's fees. So
Wow.
the number one advice I give to everybody is if you find yourself in this position, a process server comes by or a constable or whoever and drops it off. Filing a written response is key. And if you do that,
Mm.
you're going to be a leg up on 95% of people who are in that situation. You're going to be in a much
Mhm.
better overall situation to resolve it.
Wow. Wow. And so, okay. So now, when you say that they must have like something written down, what can you give us an idea of what that is, or is that something that they would get from like a lawyer, or is that something that they would create on their own?
Yeah, most people that do get sued by creditors, they end up if they do file a response, they
Yeah.
they actually do it on their own. So most people represent themselves.
Wow.
But what it is when you get sued by a creditor, the process server shows up on your door. They provide you a copy of the complaint or the
Yeah.
petition.
Real quick, if you're looking for a cheap account that's going to help you build your credit score every single month, then check out this account. It's only $10 a month and it reports to all three credit bureaus. Scan this QR code to learn more or click the link in the description below. Now back to the video.
And I say a good way to view this is really just this creditor's set of allegations that they have.
Okay.
Hasn't been proven true, just a set of allegations. And the court wants you to file a written response, essentially stating whether you admit or deny what it is they're alleging. So
Mm,
essentially, the court's wanting to know, do we have a dispute here? Okay. You have creditor alleging whatever they're alleging in their complaint. They want to
yeah.
hear from the defendant or the consumer and realize, okay, do we all agree on everything, or is there a dispute here that the court needs to be involved? So it's actually a written response. It's often called an answer.
Got you.
And you know what? You don't need a lawyer always.
Yeah.
I always say I'm biased. Obviously, sometimes it helps, but a lot of people and a lot of courts will have forms, templates, things like that. There's
Yeah.
even companies online that do a pretty good job of helping with that initial part of the lawsuit.
Got you. Okay. See, this is why we brought you here. So we can find this stuff out. But I really appreciate how you mentioned that, of course, you may not necessarily have to have a lawyer, but at the same time, it's best to have one because you never know what direction things are going to go. Especially in a situation like this. I mean, why wouldn't you want to have, the proper representation? Let's dive deeper into this. So now for people facing aggressive debt collectors, what's your advice on protecting their credit score while they're either fighting off a lawsuit or a collection?
With credit scores, so the typical life cycle of a collection account,
Yeah.
once payments stop, obviously within you're going to start getting that 30-day late, 60-day late, those things
Yeah.
showing up in the credit
Yeah.
report. And surprisingly, most credit card companies, they don't file lawsuits until one, the account is usually charged off. So there's got to be 6 months of no payments before that happens. And
Mm,
in today's credit world, most accounts are actually sold to we call them junk debt buyers, but they're debt
okay.
buyers. They go out, they pay pennies on the dollar for suits, and so a lawsuit usually comes along. It's well advanced, and truthfully, by the time the lawsuits come along, a lot of damage has probably already been done to the credit score.
Yeah.
So really, then it's trying to resolve it and get it dealt with. But same thing with the lawsuit. If you're just in the initial stages of collections, I get it that the natural inclination is, hey, I'm just going to avoid this. I'm going to not talk to people. I'm just going to avoid everything altogether. I
Right.
think whether it's a lawsuit or credit score or collections, whatever it is, taking action is going to be the thing you need to do. I always say that the creditors that are the noisiest and bark the loudest, the reason why is because they don't have a lot of options. Credit
Mm,
cards are unsecured debts. The main thing they can do is damage your credit score.
yeah.
Until they sue you and get a judgment, they can't garnish you. They can't go after your bank accounts. So the main thing is just being engaged in the process. Collectors, they want to get this. I always say they want money from you. And if you're willing to offer something and get this settled, you're going to get this behind you a lot sooner
Yeah.
and not have to worry about long-term credit issues
Yeah.
that can pop up.
Okay. Man. And like you said, it's taking action on that. And that leads me to my next question because there's a lot of bad information out here about this in particular. People say, and we want to find out for sure today from a consumer lawyer. Can a collection company, can they purchase debt? I mean, obviously they can purchase debt from a company, but are they legally allowed to collect on that money even though they didn't have your signature or they're not the original debt collector? Can they really collect the debt?
They can. So they could collect, and so the biggest debt buyers. I mean, these are gigantic companies like
Yeah.
Encore Capital. They own Midland Credit, LVNB Funding.
Yeah.
These are kind of the big collectors you see. They buy debt on huge scale. Encore
Mhm.
Capital, Midland files about 500,000 lawsuits a year throughout the
Yeah.
country.
Wow.
And so, I mean, they have to prove not only that you had the underlying account, they have to prove that, that you breached the account, that there's, damages. They have to show that they're the actual owners of it. And in my realm, that's where a lot of times the fight is because a lot of times there's a lot of sloppiness that goes on in that industry. But
Mm.
but yeah, I mean, they can if they have. I hear this too all the time.
Yeah.
on my YouTube channel. People, they can't do it. I didn't sign the contract, and I'm like, I know they can do it. I deal with it all day long and deal with lawsuits all day long. So that's that's one of those things where there are defenses that can be raised
Mm,
to these companies because you didn't enter into any contract.
yeah.
They didn't loan you money. You didn't agree to pay them money. They've got to prove to the court why it is that they should be able to collect. But absolutely, they do. And kind of, there's another one that charge offs. A lot of people feel like charge offs. You can't be sued on a charge off, and that's 100% not accurate. I see that online all the time. Charge off is more of them showing a tax loss. It's a classification
Yeah.
of the debt, not that it can't ever be collected again, because it absolutely can. So
It absolutely can. See, listen, if you all are hearing this, so all of the people that are lawyers that are not, that don't have their law licenses, people that are just giving bad advice, I'm telling you, you guys are hearing it right now. Because see, here's the thing, John, and you could probably agree with me on this, is that I think sometimes some people tell people what they want to hear, and then they start saying, oh, well, this person said or this person says it. And in reality, you're hearing it right now. But then that leads to my next question. Let's say a person has a debt with a collection company. And so that's collection company number one. Can they then sell that debt to another collection company? And if they do, does that person, are they legally liable to pay this new company?
yeah, so you'll see the debt will change hands
Yeah.
multiple times. There are different levels of debt buyers out there.
Mm,
There's the kind of the big companies that are publicly traded companies. They buy a lot of debt, but
mm,
often they'll sell it off to other debt buyers. And
wow.
so we see it. I see it routinely where debt will change hands 3, 4, 5 times. Different creditors, and again, I mean, they can ask you to voluntarily pay. If they sue you, they have to prove each of those steps along the way, which is
Right.
anytime I get a case where it's changed hands 3, 4 times, I know we have some good defenses that we can go in and get it settled for little, or even get the case thrown out.
Wow.
But yeah, they can absolutely do that. Again, they have to prove it,
Yeah.
but there are small debt buyers. Sometimes there's local companies, in each state that it's called buying paper. There's actually a really good book called Bad Paper, and it's about
Mm,
the whole debt buying industry. And
wow.
it's more scandalous. It's kind of an interesting industry where it's
Yeah.
bought and sold multiple times. But yeah, I sometimes people will not respond and they don't take action
Yeah.
because they assume that they can't do it, and it makes sense. Like I said, they didn't loan you money, you didn't agree to pay them,
Right.
but it's best to at least engage in the process and make them prove up why it is that they say you owe them money, rather than just ignore it altogether, because that's how default judgments, wage garnishments, all those horrible things get going.
Wow. Wow. So you guys heard it here first. Well, not first, but you guys heard it here for confirmation. Okay. But then that again, now I'm so glad we got you here, John. Thanks again for being here. We gotta have, if you all want us to bring John back, let us know in the comment section below, because we're gonna have John coming in here once a month. Okay. But but there is another question I have. There's a lot of people telling people to not pay their collections. They're telling people to never pay their collections. As a consumer lawyer, do you feel like that's good advice or bad advice? What's your take on that?
You know, and I don't I'm not a credit score expert, by any
Yeah.
means. I mean, I defer to people like you that have more training there. I mean,
Okay.
I do know, I mean, if an account is, 6 years old and
Yeah.
it's been charged off and you pay it, my understanding is it doesn't provide as big of a benefit as some might think it will. But I do think that there is some benefit to getting something resolved early. Even if it's settled early and there's a notation, saying settled for less than amount owed or whatever is on there, just because with collections, you're just getting hit every
Yeah.
month that's there. And that's what creates the long-term problem
Mm,
is, and I always say this, compared to even bankruptcy is just one hit in time. You file
yeah.
bankruptcy and there's one
Mhm,
date on your credit report. If you're
mhm.
just ignoring collectors, you're going to see every single month your score is going to get hit, and it's going to depress that score for, the long term.
Yeah, gotcha. So then, okay, so let's say, for example, if a person, if they just, I mean, obviously, we have people on here that have had collections before, and if they didn't pay the collection, I guess the question is, what is their legal standpoint? I mean, obviously, if they had if they had the original debt, they didn't pay it, it turns into a collection,
Mhm.
right? And essentially, legally, they're still liable for that, right? Just because of the statute of limitations, correct?
Yeah, so each state does have a statute of limitations. They range
Okay.
anywhere from as short as 2 to 3 years to up to 6 years. I've even seen 10 years in some
Yeah.
cases.
Yeah.
Like Arizona, I practice law in Arizona,
Yeah.
and the statute of limitations is 6 years. So
Okay.
the creditor, from the time that the payments stop, the creditor has 6 years to file a lawsuit on it.
Mhm.
Now, I even see debt be sold to other parties when it's outside the statute of limitations, where they'll just
Wow.
ask people to voluntarily pay on the debt. Um, so there's some legal obligation as far as I guess more of what I look at is what are their if you're not paying it, what can they do? Can they
Yeah.
sue you if they're within the statute of limitations? Yeah, they can legally still come after you.
Mm.
If even if it's outside there, they can ask you to voluntarily pay it. And so, I
Mm.
always tell you, you got to be careful on those because there's a
Yeah.
law called the Fair Debt Collection Practices Act, the
Right.
FDCPA, that says that if it's outside the statute of limitations, they have to let you know that, even in letters that they send you. You'll see that it'll say, "Hey, it's outside the time period where this debt can be collected." Those are debts I wouldn't recommend
Mhm.
settling because they're usually really old,
Yeah.
and they can't sue you. And those are I would focus on other pressing debts.
There
Uh,
you go.
those. So
Got it. And I like how you mentioned how some companies they still will try to collect debt. I mean, obviously, because they paid for it, but they can still request that you pay, but it's now voluntary, and
mhm.
they probably got that in a small fine print at the bottom. No one reads it. They end up paying it. They don't know the statute of limitations, for their particular state. So wow, that plays a major role. Okay, major role. So now, okay. So now we got this. So you guys heard it here, okay? Collection companies can sell the debt to other collection companies. This happens, like John says, multiple times. Now let's go into the back end of this. Let's say, for example, or when do you see that a person wins a lawsuit, or let's say that they have a debt they to a collection company, but then and we're not talking about credit, on like more so credit or like credit reports. We're more so talking about if they have a collection with the collection company and then they get taken to court. When do you see those cases dismissed or tossed out?
Yeah, I mean, there's some obvious ones that we see. If there's like an identity theft issue or something like
Okay.
that, where it's just not your account, those ones can be thrown out. We see it a lot with. I really break debt collection lawsuits into two groups. There's what
Okay.
I call original creditor cases. There's some credit card companies that do not sell their debt. American
Yeah.
Express doesn't sell their debt; they sue on it themselves. Those kind
Mm,
of cases are very hard to prevail on. Uh,
mm,
they're going to have their documents, they're going to have their witnesses. They have all the information because it was their account.
yeah.
But the debt buyer cases, when accounts are sold
Yeah.
to junk debt buyers, surprisingly, when they do these large transactions, very little gets transferred from the original creditor to the new debt buyer. I
Mm,
mean, maybe it's usually just a spreadsheet with some names, addresses, account numbers, and they just start collecting. They don't have witnesses, they don't have the documents they need to establish their ownership. So those are the kind of cases that I usually get involved with where we're fighting them, where debt buyers are unable to show that they are the actual owner of the account.
yeah.
They've got to have standing or what we call privity. They've got to have a contractual relationship with the consumer to be able to, collect money from them. And so those are the kind of cases if you have a debt buyer, not only that, it's important to know if you're trying to even settle it pre
Yeah.
lawsuit, debt buyers pay. There was an FTC study that showed most debt buyers pay about 4 cents on the dollar. So
Mm,
you're going to get a much better settlement than,
yeah.
if American Express sues you, you're probably going to pay 60 to 80 cents on the dollar to settle it. Where if
Yeah.
you get sued by a debt buyer, they might only have, you know, like I said, 4 cents on the dollar invested in this thing. You may be able to settle it for
Yeah.
25% or 10% of the total amount. So yeah, it
Yeah.
makes a big difference if it's been sold or not, whether you can, as far as how you get it resolved.
Got you. Man, this is such good information. I know sometimes, John, you probably talk to some people, they don't appreciate this information, but I promise you, our audience does. We greatly appreciate this information. So
Well,
there's another piece I wanted to ask as well too. And now sometimes people are able to get items removed from their credit reports. Um, and it's accurate information. Like, for example, I'll just give a simple scenario. They owe a company money, they figure out a way to get it removed off of their credit report, but it's actually accurate, right? And because the report is just the report.
Yeah.
Legally, does that person still owe the money even though it's not on their report?
Yeah, credit reporting really is a completely separate issue from liability on a debt.
Yeah.
Because there really isn't, I mean, there's most debts, I wouldn't say most, but a lot of debts are, there's no obligation that a creditor actually report on the credit report.
Mm,
I always use that approach when we're trying to kind of a pay for delete thing. And because
yeah,
the Fair Credit Reporting Act says that they have to report accurately.
that's right.
I say, I get that, but you don't have to report at all. There's no
Mm,
requirement that you report. The company can elect not to. So the fact that credit reporting is just, for there to create this credit score that, runs all of our lives.
right.
But it doesn't really tie directly to the debt.
Yeah,
We see it a lot with medical bills,
yeah,
particularly smaller medical bills that aren't showing up on a credit report. There's still liability on the debt. They could still technically sue you for it or call you and ask for payment. So just because it's not showing up on the report doesn't necessarily mean that it's uncollectible. If it's really old, it may be outside the statute of limitations. If a collection has fallen off of your credit report, so that's something that it may not legally be collectible at that point. But
yeah.
yeah, no, I think that to say that just because it's not on the credit report, that's where people could run into problems if they just ignore it because of that issue alone.
There you go. There you go. We need that. We need this. Some people that are watching this right now, John, they need that confirmation because I've heard people say, "Oh, well, it's not on my credit report or it's falling off." That's a completely separate matter than the statute of limitations and
Yeah.
if you owe the debt or not. So I'm glad that you mentioned that as well. Let's go into bankruptcy. I know right now, a lot of people are feeling the squeeze right now inside the economy, and some people are contemplating bankruptcy. How does a person know that they should consider bankruptcy and whether they should choose between a chapter 7 or a chapter 13?
Debt that you need to have to file. There's
Yeah.
no legal requirement that you have a certain amount of debt.
Okay.
I really, when I talk to clients here in my practice in Arizona, we really look at just the ability to pay.
Yeah.
Is there life circumstances? Are there medical issues, job loss? I can say when most people get, 50 to 100 grand in credit card debt, which, we see pretty routinely, that's when, particularly depending on the job, if they don't have the income to support that, where
Yeah.
we really start looking at a bankruptcy filing. Um, but that being said, I've had clients with $100,000 of credit card debt who've had sufficient income to be able to come up with some type of payment plan or something to get a current. And I've also filed a bankruptcy one time. I remember it was a lady who had $8,000, but she was on this Social Security disability, and there was just no way and
Yeah.
that she was ever going to be able to pay it. So it is very, case by case as far as the amount. But I do say this: if it's something where, Dave Ramsey calls it the four walls. If you're not able to pay, your rent, groceries,
Yeah.
utility bills, if you're in that situation because you're paying the minimums to credit cards, it's
Yeah.
it's probably time to start at least talking to someone to consider the bankruptcy option so that you're not going without necessities to be able to cover those minimum payments. And I see that all the time. People are
Yeah.
not buying groceries literally to keep up on their monthly minimums. That's,
Yeah.
I think, when you need to start considering it. Whether it's a chapter 7 or chapter 13, a lot of times that decision is made for you because you have to qualify for a chapter 7. There's a
Mm.
means test, and this is something changed back in 2005, where
Wow.
now they look at your income,
Yeah.
they look at the number of people in your household, and then
Mm.
based on the state, because it's different for each state.
Yeah.
So, for example, right in Arizona right now, an individual, if you make $70,000 a year or less, you qualify for a Chapter 7. But if,
Wow.
but if you make 90, you're probably gonna have to look at a Chapter 13.
Yep.
And it goes up, by the number of, and it's not even just spouses and kids in that. It's actually, if you have a brother-in-law or a grandmother living with you, it's the number of people in the household that can help you to qualify. Um,
Wow.
Chapter 7 is what most cases are filed under.
Yeah.
It's what people think about. It just eliminates unsecured debts, credit cards, medical bills, personal loans. Those go away completely. They're
Okay.
discharged. The trade-off is that in Chapter 7, they're going to look to see if you have any assets that can be sold for
Mm,
the benefit of creditors. Most things are protected. There's exemption laws in every state that protect, homes and cars and retirement accounts and that kind of thing.
yeah.
Chapter 13 is a much longer process. It's a 5-year process where Chapter
Mm,
7 is only about 4 months.
yeah.
Chapter 13 is really designed for people who either don't qualify for a Chapter 7 because their income is too high, or if someone comes to me and says, "Hey, I'm 4 months behind on my house payment, they're going to foreclose on me."
Yeah.
We can file a Chapter 13, stop the foreclosure, and the court will give you up to 5 years to get that caught up. So it has a
Wow.
lot more kind of tools. But overwhelmingly, Chapter 7 is probably about 90% of the filings nationwide.
Wow. Wow, that's good to know. Then see a lot of man, and there's some pieces I knew about that, but it's most definitely a lot of pieces I did not know about that for sure. It's going to be based on your income as which route you're going to end up, the options that you're going to have between the two. Okay, and I have another question. There are some people right now I know that are going through this, and that's wage garnishment. At what point can a company decide that they want to start the wage garnishment process? Can they do it at any time, or what's the qualifications for that, if any?
Yeah, I mean, wage garnishment in most situations cannot happen until the creditor sues you, gets a judgment against you, and then they get a writ of garnishment that they serve on your employer
Mm,
or your bank account. And each state has laws that say how much. Like in Arizona, they can take 10% of your net wages.
wow.
Um, but like the federal government, they can garnish up to 25% of your
Mm,
paycheck. So it's something where if they usually have to go through that process first.
yeah.
So it's, you would, the problem we run into often is that people aren't aware they've been sued, which sounds
Wow.
crazy,
Yeah.
but it happens all the time because of kind of the volume of debt collection. Some of these debt buyers, they don't really give proper notice to people and they get a judgment, but they can't do it until they get a judgment. And so that's what I
Yeah.
tell people. If you're trying to settle something early on, a lot of people are panicking because they think their wages are going to get garnished. That's not going to happen until they've actually sued you. They came by your house, dropped off a lawsuit, taken you to court. If it does advance to the point where there is a wage garnishment, though, that's something where at that stage it gets really tough to settle,
Yeah.
because people say, well, I'll do a payment plan. And the creditor says, I've got my payment plan. I'm taking 10% of your wages every 2 weeks, kind of things.
Wow.
So yeah, so it's something where you want to avoid that. I see wage garnishment is probably the number one thing that pushes people into a bankruptcy situation.
Mm,
Because the bankruptcy will stop the wage garnishment immediately. So, but yeah, it's usually well down the line before anything like that'll happen.
got you. Wow. That's good to know that it can't start unless they're already essentially pretty much taking you to court, already. They've already tried to, get the debt. So they can't skip any steps
Yep.
there. Okay, man. This is amazing information, John. I just want to say thank you, of course, for being here. Listen, guys, let us know inside the comment section below if you all want us to bring John back. Okay. If you want us to bring John back, let us know inside the comment section below. And listen, guys, if you haven't done anything today, outside of taking notes, make sure you stop by his YouTube channel. He talks about this stuff all the time, whether it's collections, bankruptcy, wage garnishment. Make sure you guys go ahead and subscribe to his channel today. Well, listen, John, listen, we know you got some other clients to get to so you can be their consumer warrior. So listen, but we greatly appreciate you being here today. Is there anything that you want to leave with us before we get out of here?
I would just say take action. The number one problem I see in my practice is when things just get ignored. Like I said, I get it. We always go to this terrible place that something. We're going to go to jail. I should say this: there's no jail, there are no debtor prisons anymore. But so just reaching out and trying to get these things resolved. The earlier you can do it, the better it's going to be. Whether it's credit score or avoiding garnishments or lawsuits, all that kind of stuff, is just taking action is going to be the main thing I would tell people.
There you go. Taking action, guys, not ignoring it. Not ignoring it. Thank you so much, John, for being here. Make sure you guys go to subscribe to his channel. And until next time, John, thanks again.
All right. Thanks for having me.
Thanks for watching, and we'll see you guys on the next video.